Today we want to talk about agency, and we'll show you a few examples in a second. But we have to recognize that an agent can act in our stead. That's the reason we hire an agent. In a real estate transaction, we oftentimes do this because it's a confusing field. We're going to do it 1 to 2 to 5 times in our life, perhaps more. If we're a Donald Trump, we may not need an agent, but we may. Anyway, agents can help us, but they can also create liability. But generally, the power of an agent is to act in our stead. One area we may think about is where relatives can occasionally act as your agent for healthcare decisions or financial decisions, particularly later in life. We may not be able to take care of ourselves and we may need somebody else to do it. But in a business setting, the boss can't be there for every transaction, has to do something about it. So let's look at some examples. And I'm not sure why the Cubs pop up here, but we'll see if that plays out. In real estate, as I already talked about, it's probably wise to always have an agent here unless you really understand real estate transactions. There are a lot of little nuances that go into it. A good agent, one who really has your best interests at heart, which isn't always true. I mean, it's a commission-based business. Should help you through some of the morass of what should you do? Should I get an inspection? Do I need to have everything fixed on it? But ordinarily, we think we're going to hire this person, we're going to pay them their commission, and that will be the end of our agency with them. Other agents we would think about are insurance agents. And here I've put a kind of distinction between them. You may have a captive insurance agent, that is, they sell Liberty Mutual policies only, or an independent agent who maybe can get a Liberty Mutual policy for you, or a State Farm, or whatever. Oftentimes, independent agents really deal with 5 or 6 companies. Oftentimes, what they're dealing with is more of a business type insurance where there's some specialization within the insurance companies that we may need to draw upon expertise of a variety of companies or be able to compare the coverages of a variety of companies. The captive agent can only sell you that one product. The independent agent ostensibly can shop for others. Which is best? I'm not certain. The captive agent has a lot of power with the home office. For instance, State Farm Country Mutual, if the agent calls and says, my insured's not happy, things happen. And they generally happen for the good of the insured. Here's my query. In entertainment, of course, we always think of movie stars and others having an agent. Taylor Swift may not have an agent. I think she does her own stuff. But there is an agent in the background, but she does a lot of her own stuff. But my query here is, are the agents for the Chicago Cubs really providing entertainment? Well, if we look at the date of these slides, we can see why. If you look at the Cubs in 2014, they were probably pretty bad. Chris Bryant may have just come up that year, and he was struggling a little. And anyway, the Cubs were a perennial doormat. Well, they've fixed that, and now they're a dominant team. They may become the Yankees of this decade. We'll see. But if you go back through history, the Cubs have been an up and down team. Sometimes their play is just incredibly bad. And so we do have to worry about whether they're entertainment. But the agents for movie stars get like 10%. I mean, the pay is really good. The pay is extremely good. But they bring in some expertise, and they also can help with that Management doesn't want to pay too much, but they also want to keep the person happy. So some of the negotiation, if the player is not there, the harmful stuff that might be said in negotiations, the player never has to hear it. A smart agent may come back and say, well, they're worried about X, Y, and Z. They're not going to give the full throat that the management does. Of course, we always have secret agents, and for that, we can think of Maxwell Smart. And I can't remember the name of that really funny movie with Steve Carell, but and Anne Hathaway. If you've never seen it, I recommend it. Is it Get Smart? Yeah, it's Get Smart. It's the name of the TV show. All right, so let's look at how do we get to formation and operation of the agency agreement. Generally, the principal and the agent contract for the services. The simplest example that I can come up with is employer-employee. Each employee is an agent for the employer, and that brings with it things that might be borderline fiduciary duty. And the fiduciary duty, I always tell students, whether I'm right on this or not, that they ought to look at the fiduciary duty as a good way to live life. Treat each transaction as though you have a deeper duty to the other party in it. Always approach it as though I'm not necessarily the one who needs to get out of the most out of this. Yeah, that's tough in a business situation, and it may not always work. But sometimes getting over on somebody ends a period of cooperation with them forever. If we can keep both of us in business, in a business setting, we're in good shape. One thing we need to worry about here is the duty of loyalty. A fair number of employees think that if somebody offers them a job related to the job they're doing for their boss, they're free to take that job on the weekend. Well, it's not when I'm working for my boss. For instance, I had some movers who, during the process of moving, approached me about, hey, I can help you move some of this stuff over the weekend. It's a lot cheaper. And I'm like, what? No, I hired your boss, and I expect you guys to put everything on the boat. It was really weird. I don't know that you've encountered this, but you got to be careful. So, for instance, say you're working for Donald Trump, and someone says, "Hey, here's this. I know you work for Trump. I've got this property that I think you ought to look at." You go look at the property, and like, I don't need Trump in on this. I can do this. Well, no, Mr. Trump has hired you. You are his agent. You have a duty to give that to Mr. Trump. If he's not interested, then you can. Or his organization is not interested, then you're free to operate on it ordinarily. But, check with the lawyer first. So let's look at the authority to act on behalf of the principal. So first of all, express agency. It's actually written out. Here it is. You are my agent. Pretty simple example, power of attorney. I probably put this in because my parents were getting a little older, and we had to start doing power of attorney for healthcare decisions, because they may go into the hospital, have a procedure done, and come out of it not as strong as they used to be. And so the doctors need somebody there who can say yay or nay on further treatment, that sort of stuff. And they also need it so that it's not every potential relative. They can say, no, this person is the only one who has power of attorney. We're only talking to them. They can talk with you and make sure it works right, but we're going to only listen to them. We won't always have an express agreement coming out. When we go to the Hardee's, do we expect that the kid at the counter or the lady at the counter or the man at the counter is an agent of that entity. Yes, but we may know there's also a franchise in there, but it's implied that they are an agent. They're wearing the costume, if you will. They have an authority to engage in certain things that would give us necessary acts. Now, that they've got the power to do the window transaction, but if I were to come in and talk to the guy at the desk and say, hey, can I do all your landscaping here? And he says, yeah, sure, that'd be great. Well, because it gets him out of it. I don't have any way to imply that the guy working the window at Hardee's has the authority to approve me being the landscape architect or whatever for that entity. I know I've got to go to the right person. So as we're doing this implication, it's what's reasonable. Is it really reasonable that the person sent over to fix my air conditioning system can also can also do my roof, even if the company does roofing? No, I don't think so. I think that I probably need to say, hey, I also need this roof done. Can you see about what is going on? And then they might do it. Now, one of the things we do see, though, is if an agent exceeds authority or does something that is in excess of authority, but the boss or the principal doesn't say anything about, hey, that guy had no authority to bind, they may get themselves into the tenuous grasp of ratification. They may have ratified by assent or by failure to object to this activity. So that, for instance, they let me come in and trim all the hedges, and I send them a bill, they pay it. I think I've got a good argument that they've ratified that guy bound me, and I've now got whatever I thought the terms were of the agreement are now coming in on me. So if I go do the work again next month, as what he and I discussed, or she and I discussed, I should get paid every time. Not the best place for me, I grant you. I'd rather have it in writing from the right person. Okay? We have also this apparent authority. I always struggle a little bit here, but if I'm trying to sell my home and a real estate agent calls me, and say makes me an offer for their client, and I say, yeah, I would accept that. To me, they have that apparent authority. They've identified themselves through it. With this phrase, authority by estoppel, plausible deniability. Once someone has induced me to act to my detriment, and they knew that I would act based upon what they said, they are generally estopped to deny it. That is, they cannot deny that they compelled me to act. And so this is a tenuous area of the law. I don't like to rely on estoppel. I see it upheld in courts. That doesn't necessarily get us much of anything. I don't want to see anybody in a courthouse relative to a contract I negotiated or a contract I was performing. At the same time, the law does favor kind of continuous transactions. It will not undo idiocy on your part. That's your problem. But if what you relied upon was reasonable by all external circumstances, not by what you personally thought, but what a reasonable person would think, you're in pretty good shape. you're better off, as always, get it in writing. That's much better. It's way easier to enforce. You don't have to have the lawyers running up uh, big bills explaining estoppel to judges. This is the one phrase I remember coming out of law school. Most of us agreed, I'm not sure I get that estoppel stuff. So, most of these law students, were a variable sort, but most of us thought we weren't really that well schooled in it. So let's look at some of the agent's duties and some of the ethical deals going on. Duty of loyalty, as we already talked about, self-dealing. Um, you know, say you're my agent to deal with Richard Rawlings on buying some souped-up car that Gas Monkey Garage created. And I send you down and give you 30 grand or whatever we thought is the top deal. Well, you go down there and buy it for yourself for 23 grand. No, you've done self-dealing. I really should have had that. Um, Usurping an opportunity. I think I explained that to you in the Trump example. Someone comes to the Trump people and says, hey, I've got this property. Would you think about developing it? And then we don't ever tell Trump. No, that opportunity belongs to the principal. There's always the worry in here of competing with the principal as an agent. I may be privy to some internal material that makes it possible for me to compete with the principal on price. I know what it really costs them to get this good to market. Well, I might find a different manufacturer who can make essentially the same item for less money and compete with my own boss. That hopefully that just doesn't ring true to you. A little bit of the same thing with misuse of confidential information. I could say things about my company that could harm it long term simply because I know the inner workings of the company. I mean, we all have warts, and sometimes as an employee, it's your job to kind of paint over them, and not to lie necessarily, but to say, no, we can really do this. There is there are places where you can act as a dual agent. As long as you got the signatures of the buyer and the seller in a real estate contract, you can work for both sides. It's an inherent conflict of interest because the buyer wants to pay the least possible and the seller wants to get the most possible. And you want to get a commission, and you're going to get both sides of the commission. It seems like that's more commission driven, and one should avoid that kind of thing. But it is permitted as long as you take care of it. Sorry about all the email beeps here. I guess I should maybe I need to turn my volume way down. That's what I need to do. And we won't get those. Sorry about that. I should have muted it. That's probably an even better idea. Here's a big area of agency: tort liability to third parties. I'm driving a car to go from one location for my boss to another, and I get in a wreck. Guess what? Under the doctrine of Respondeat superior, which is kind of a deep pockets doctrine, if I'm on my master's business, my negligence can be attributed to my master. So that and we still use the master and servant language, even though slavery has made this something we probably shouldn't be talking about, but it's still there embedded in the law. And the thinking behind it is fairly good, even though it also goes back to Roman slavery days. We've broken out of that somewhat. So let's look at this. This is a doctrine of vicarious liability. I, as your employer, am liable for your mistakes because you are my agent. But it should also be noted that the agent is also liable. That, just because I did it while my boss was going, or my boss, while I was employed, um, doesn't mean I'm not at fault, and I may not, I may have to pay additional damages. Let's say my boss's insurance policy is only $1 million, and I do $1.5 million in damages. I'm on the hook for that extra half a million. My boss might be too, but if I happen to have the assets, the plaintiff's attorney can take their money wherever they get it. So, if I look at that, it's pretty likely my insurance company is going to say, no, we don't insure you. It's very plain in our policy. We don't insure you while you're working. We insure you while you're commuting. And this, so for instance, frolic and detour. Let's say I'm on the way to my boss's, I'm going to our other plant, but I stop at my house, have some lunch, or I'm on my way to my house. I may be on what's called a frolic and detour. I may have left the service of my master, and I'm now just serving me. Where does this end? It can be a little fuzzy. The lunch example is not always that good, but you can see this. Commuting to and from I hope you can see it, that, maybe you're not completely on your boss's business anymore. Now, this oftentimes is a battle between insurance companies, which doesn't necessarily affect us. But if the damages are big enough, my boss is likely to have a bigger policy than I am because they have a whole bunch more people who may be negligent than just me. I can kind of say I'm only going to have a 100, 300 policy because my way of thinking, that's the most I'm ever going to cause in an auto accident. Now, my personal way of thinking is no, I always buy a $1 million umbrella, make myself a real target of people. Now people will be running into me. But it's because I don't necessarily know what the damages may be going out. And from an insurance standpoint, the additional dollars of coverage are relatively cheap. I've had them for a long time, and I've made the best use of them. I've never had to use them, but they're sitting there. It gives me a lot of comfort as I go forward. It should be noted that commuting to and from work is not on the business of your master. All right. Once you hit the work and once you leave it on the business of your master, you're no longer commuting. We can get into these places where it could be a dual purpose mission. I went by my house to gather a file that I had forgotten. Well, let's take it this, is that really your boss's fault that you forgot it? Or did I go there because I had left it at home, I was working on it, and then something came up at the office, I needed to have it. And so I actually detoured in order to get to it. We can maybe come up with a set of facts where we have sort of a split mission here. Yeah, I did grab lunch, but that was only because it's cheaper for me to eat leftovers at home. My real purpose in going home was that I had to get something for work, and it just happened to be near lunchtime that I did it. We should look at the fact that an intentional tort is likely not going to fall under the doctrine of respondeat superior. Where does the line come from intentional torts? To me, what pops into my brain at this moment is potentially defamation. I intentionally said something nasty about somebody else, and it's not really in furtherance of my master's business. It's pretty likely that's on me, not on my boss. Potentially, maybe I've got I've got a drinking problem related to work, granted, but there are times where I've seen this. It's kind of rare, but this one's one of the weird ones. got so drunk that they knew or should have known they were going to really hurt somebody, and it borders on an intent because you had the intent to get drunk when you were drinking. Yeah, it's not going to hold a real good solid water, because there comes a point where you no longer control your drinking. Once you hit that, once certain people at least hit that high point, they oftentimes can no longer control it. They just keep drinking. Um, Another interesting one is misrepresentations. If you know the facts to be otherwise and you misrepresent them to somebody, they then rely upon that misrepresentation. Unless your boss told you to lie, it's on you. If your boss is the one who told you to, then we now may be in an intentional tort position where neither of you has insurance coverage. But anything intended or expected from the standpoint of the insured is excluded from almost all liability policies. I can't think of one right now. There probably are examples, but you're going to pay a lot of extra money to get coverage for intentional torts, because why would you cover somebody? I mean, that may be against public policy at the state level. And there's the great, what do they call him, the Wizard of Omaha, the great Warren Buffett. That's his car, folks. It is not a Benz. I think it's an old Alero. Is what Warren Buffett drives. He drives himself. I don't know if he still does, but he drove himself at least to the point where these slides were produced about 3 years ago. The last part of agency, and we're on slide 7, so hopefully we're near the end. Talks about contract liability. And pardon me, I've got to get a drink of water. Where the principal is completely disclosed, real estate transaction. I'm working on behalf of the Baileys. The agent is not liable. All right. Where the agent and principal principal is partially disclosed. I'm working on behalf of a qualified buyer, but I'm not going to tell you exactly who it is, or it's somebody in this field or blah, blah, blah. The agent and the principal are both liable. So the agent needs to be careful here. If I'm going to engage in these kinds of transactions, I may be on the hook too. So it may be that my principal backs out, but guess what? Because I've bound that other party to some side of performance, once they perform, I owe it. All right. The last one is undisclosed principal, and I think these are kind of cool. But here's why Warren Buffett is there. Let's say I want to sell my old Zalero to somebody, and that somebody turns out to be Warren Buffett. Well, the price just went up. Same thing if Warren Buffett walks in and now this is something Buffett does all the time. He actually walks in and talks to people personally. His agents, when they're interested in buying a business, they actually fully disclose themselves, I believe. Trump, I think, on the other hand, does not. He does more of the, hey, we're thinking about developing this. They're kind of a little bit more secretive. It's the same thing. If Taylor Swift wants to buy a property in Narragansett or Rhode Island or off on the islands or something like that, and the seller knows it's Taylor Swift, boom, the price just doubled. But if the seller doesn't know, but only knows, no, I'm an agent for a prominent individual, they don't want to disclose who they are, they can definitely afford it. You can check on me, the agent, to see whether I'm trustworthy and honest and all that sort of thing. But, it's somebody who has the money here, but they don't, so they can try to, the seller can try to get more money out of them, but, at some point in time, it's just certain value. Madonna doesn't want to pay double and triple value for her estate in Nice. No, so, but we oftentimes use that. I think another example is the McKeagle property up in North St. Louis. The guy who has all of that stuff, and I'm blanking on his name, basically sent a bunch of his own agents in, and they were acting under cover of their own private authority. They were not revealing who they were working for, but he would send 4 or 5 of them into tax auction sales. That way, we couldn't really be certain that it was any one entity who was buying. It was probably, and these happens a lot in that kind of sale, that there's an agent who goes in and has certain authority to bid to a certain extent, and they may actually be working for a multitude of clients, but it's a good cover, because what happened is ultimately McKeagle wound up owning like 80% of North St. Louis. I probably have the number wrong, but had he been trying to buy those properties individually, he would have found that the price of the last property would have been enormous. Same thing sort of happened in the building of the United Nations Center in downtown Manhattan. As they're buying the property, they made it very carefully that they did it without each property owner knowing, hey, we're trying to buy up this particular block here. And they did it over time, and they sort of did it on a speculative venture that at a later point in time, something like the United Nations would love to have all this property, but if we've got to assemble it all to ourselves, then we can sell it to them. So in that case, we definitely didn't want to disclose principal, because that always makes that last piece of property very expensive. If you don't believe me, look at condemnation proceedings where they know the railroad's coming through here. Sometimes they're almost hold-up stuff. The last thing I believe we've got to look at in here is the independent contractor. This is an old form, and you can see probably from looking at the agency liability, well, maybe I'm just going to presume I'm going to make this person an independent contractor. That only works so far. The law sort of presumes if they're working for you, they're your agent. You better have, at least for third parties, a real good reason why we should treat them independently. Because as you can see by the doctrine of Respondeat superior, generally the person who can afford to hire an agent has more money in their pocket than the person who's acting as an agent. Not always true, but a good general statement. So let's look at what some of the indicia are of independent contractor. And let me make another comment that a lot of people, as they age out in a corporation, are oftentimes let go, and then within 3 to 6 months hired back as an independent contractor. Well, what does that mean? It means they don't get any health benefit. They're not going to qualify for the retirement plan. You're on your own. Yeah, we're going to pay you, say, 30% more than we paid you before, but you're liable for all of your benefits yourself. So the indicia of, is this an independent contractor, tends to be, what is the degree of control over the behavior of the agent? Do we control the manner and means in which they do business? Do we control the method, the timing? Do we actually pay them directly, or do they get paid by their customer that they're selling to? The example that I dealt with in my career was like a Snap-on tool type of guy. They have their own truck. Well, they try to characterize these guys as independent contractors, but guess what? They can't just have their own truck. They have to have a truck that says Snap-on Tools on it or whatever it was. And they were given a limited territory. Whereas an independent contractor can maybe go, no, that's too small. My territory's got to be bigger than this. So, while we might, as an employer, be able to characterize someone as an independent contractor, we got to be careful that we're not overly controlling them, or that we're really letting them do their work under their own independent system. At the same time, that doesn't mean we can't, demand that this project be done by X date. But innocent third parties cannot be bound by this relationship. We're also, one of the indicia we may always see is that there's a reason to have this person as an independent contractor. We really only want them for this project, and we won't hire them for, just keep going. We aren't paying any benefits. Benefits doesn't necessarily mean lack of agency, or lack of benefits doesn't mean lack of agency. That's more between the two parties, but it is a benefit for the employer who doesn't have to pay benefits. And I was right. That's the end of it. Thanks.